The court is now in session. Today, the Chamber will hear oral responses from parties on two issues. First, there is the remaining charges in case 002, and second, that is the available resources for the two defense teams. Ms. Sakalwati, please report the attendance of the parties and other individuals through today's proceedings. Grazie, Mr. President. For today's proceedings, all parties to this case are present. Mr. Nguyen is present in the holding cell downstairs. He has waived his rights to be present in the courtroom. The waiver has been delivered to the greffier. Thank you. President, thank you. The Chamber now decides on the request by Nguyen Chia. The Chamber has received a waiver from Nguyen Chia dated 11 January 2017, which states that due to his health, that is headache, back pain, he cannot sit or concentrate for long, and in order to effectively participate in future hearings, he requests to waive his rights to be present at the 11 January 2017 hearing. Having seen the medical report of Nguyen Chia by the duty doctor for the accused at the ECCC, dated 11 January 2017, which notes that today, Nguyen Chia has a lower back pain and feels dizzy when he sits for long, and recommends that the Chamber shall grant him his request so that he can follow the proceedings remotely from the holding cell downstairs. Based on the above information and pursuant to Rule 81.5 of the ECCC internal rules, the Chamber grants Nguyen Chia his request to follow today's proceedings remotely from the holding cell downstairs via an audio-visual means. The Chamber instructs the AV unit personnel to link the proceedings to the room downstairs so that Nguyen Chia can follow. That applies for the whole day. First, the Chamber will hear oral submissions from parties on the remaining charges in case 002. On the 9th September 2016, the lead co-lawyers for civil parties made a submissions on the remaining for clarification on the remaining charges in case 002. That is document E439. The defense counsels for Kieu Sampon, for Nguyen Chia, and the co-prosecutors responded to the submission. There is documents E439/1, E439/2, E439/3, respectively. Lead co-lawyers for civil parties replied to the responses of Nguyen Chia on the 23rd September 2016. There is document E439/4. On the 16th December 2016, the Chamber notified parties via an email that the Chamber would set a date to hear oral submissions from parties concerning the remaining charges in case 002 immediately after the conclusions of the evidentiary hearing in case 002/02. However, on the morning of 10 January 2016, the Chamber further notified the parties that the Chamber could not hear the testimony of 2TCW 946 via video link on the afternoons of 10 and 11 of January 2016. For that reason, the Chamber asked the parties to prepare their oral submissions on the remaining charges in case 002 on Wednesday morning, 11 January 2016. For that reason, the Chamber would like to hear oral responses from parties on this issue. And first, the Chamber hands the floor to the lead co-lawyers for civil parties to make their oral summary on their submission, and the combined time for the lead co-lawyers and the co-prosecutors is one court session. Lead co-lawyers, you have the floor.
Thank you, Mr. President, and good morning to all of you. This is a subject that is particularly important for the civil parties, so I'm going to try to be as clear as possible by trying to speak slowly so that the interpreters may follow our argumentation that at times may be a bit technical, shall we say. It is important to recall for the Chamber, but even more so for the public, that the civil parties, since the 2010 change, are participating in this trial through a group, and that they're no longer participating on an individual basis in these trials. So our entire reflection is very important because now it is involving the group that is made up of 3,800 and so on civil parties. And the Chamber remembers, I'm sure, that the civil parties, since the beginning of these proceedings, have always followed the principle that the facts that are contained in the closing order of case 002 had to be tried for the very simple reason that some of the civil parties have suffered from facts that have not yet been tried or even examined by the Chamber in cases 002/1 and case 002/2. And I would like also to explain to the Chamber the way that we proceeded in order to carry out our consultations with the civil parties, and by reminding to the Chamber and the parties the factors that we took into account to carry out these consultations, by providing a few figures as well to the Chamber, because I believe it's important that the Chamber understand exactly which subgroups are impacted by this discussion within the civil party consolidated group. And I also would like to say a few words on the consultation process that we set up, and then provide our conclusion to the Chamber. So the objective of our discussions was for Ampik and myself to try to underline the general interest of the consolidated group, and in order to do so, we had in mind the idea of listening to the civil parties, and listening in particular to the civil parties that suffered directly from the facts that for the moment have not yet been tried or considered by the Chamber. And a few factors guided our thought process. And the first of these factors is that the civil parties are aged. And the Chamber knows this. More than 200 civil parties have died since the beginning of case 002. And as an example, we learned this weekend that a civil party that the Chamber knows very well died. This is Nosates, the Cham civil party who came to testify on the Trea village, Nosates died, this village, and we received this news on a daily basis. And it's important as well for the Chamber to know that more than 400 civil parties are considered too aged or too ill to partake in these proceedings. That is to say, for example, to go to the information forum or to the forums regarding the reparations. So first criteria, age, which of course is a fundamental criteria in the thought process that we carried out. And the second criteria is the length of the trial. We should not forget that the civil parties started their legal adventure 10 years ago, for most of them. And time is long. And of course, we have to take this factor into consideration. The third factor that guided our thinking is the reality of this trial. That is to say that we're speaking today about a trial that concerns the same defendants, Khieu Samphan and Nuon Chea. Khieu Samphan and Nuon Chea have been convicted for having partaken in a criminal project which was at the heart of the harm that all of the civil parties suffered from. And in this capacity, the Supreme Court's decision, or in this regard, the Supreme Court's decision that reminded us that the revolutionary project of democratic Kampuchea was a criminal project, allows us, at least, or allows the civil parties at least, to find some kind of answer to the harm that they suffered. And another element that we took into consideration is the fact that the civil parties who are victims, direct victims of the facts that remain, have already all participated through the consolidated group in the hearings of cases 2.1 and 2.2, but also sometimes in the reparation projects linked to case 021. And finally, the last criteria that we took into consideration is the possibility of imagining measures, non-judiciary measures, that may address the expectations of the civil parties who are directly concerned by the facts that would be part of a possible case 2.3. So what we try to imagine is that if the Chamber put an end to case 2, which measures could we consider to address the expectations of the civil parties in a non-judiciary context? And the Chamber knows that the internal rules provide leads because there is the possibility to set up non-judiciary measures for the victims. After having given you an overview of the factors that guided our thinking, I would like to give to the Chamber a few figures because it seems important to me to guide your deliberations. The consolidated group is made up of 3,800 civil parties, 3,860 on paper, but now we have more than 200 civil parties who have died. And within this group of civil parties, 446 were admitted as direct victims or indirect victims of the facts that remain in case 2, the remaining charges in case 2. And I'd like to specify to the Chambers and to the parties that we based ourselves on the admissibility criteria of the OCIJ, which is the only objective criterion that allows the Chambers and the parties to understand the figures that we arrived at. And I'd like to remind to the Chamber that these admissibility criteria were not decided by us. It is the OCIJ back then that decided on these criteria, and it's important to remind as well that these criteria are not exhaustive, and therefore sometimes the OCIJ admitted a civil party on the basis of one single criterion, whereas de facto the civil party had been a victim of several facts within the scope of case 2. Let me give you an example. A civil party may have been admitted on the basis of the treatment of the Cham, because the civil party is a Cham, and then you notice, finally speaking, that the civil party was also a victim of forced marriages. So 446 civil parties were admitted as direct victims or indirect victims of the facts that remain, of the charges that remain. A great portion of these civil parties were admitted under the heading of forced transfers and the treatment of Buddhists. So when we withdraw these two admissibility criteria, we have still 60 civil parties who were admitted only as victims of the remaining charges in case 2, except for the treatment of Buddhists and forced transfer number 3. Maybe it might be useful to remind you that the remaining charges regard essentially security centers, Kokyang Security Center, for example, Predam Reisrot Security Center, the execution sites of District 12, the security center of Sang, the security center of Wat Kirirom, the security center of the North Zone, and the work site of Presaw, the work site of Srei Ambal, and the security center of Kokkodok. So if we consider all of these sites except for the treatment of Buddhists and forced transfer number 3, we come up with a total of 60 civil parties who are concerned. Out of these 60, 34 only were admitted on this mere or sole basis, that is to say, for having only been victims of these particular facts. The remainder of these civil parties were admitted in connection with other facts. So, it is necessary to note that aside from forced transfer number 3 and for the treatment of Buddhists, the direct victims that are concerned by the remaining facts are a minority within the consolidated group. So with these figures in mind, we decided to carry out consultations to try to understand the general interest of the consolidated group, and we acted in 2 steps. First, we consulted all of the lawyers in August of last year, and then we organized direct consultations with the civil parties in the presence of the lawyers by, first of all, consulting the direct victims of the remaining facts, that in order to understand what they wished, and then we carried out other consultations with the civil parties of the consolidated group in order to understand if they wanted the trial to continue or not. And the conclusion that we drew from this consultation process is that the call for justice remains a priority for the civil parties, and that many civil parties wish the trial to continue. And at the same time, an even greater number of civil parties wish that measures be developed in order to support them. And therefore, we're speaking here about non-judiciary measures, but measures aiming at supporting the civil parties in their day-to-day lives and in their needs to talk about what they experienced under the DK period. I hope that the Chamber and the parties followed me. I have the impression that I was clear in French, and I felt that some people were a bit skeptical among the non-French speakers, so I hope that the Chamber followed my figures, because we're trying, of course, to be as transparent as possible in order to explain to you the decision that we reached, because it is up to Ang Peek and to myself to synthesize all of this work and to keep in mind that the internal rules order us to do all of this within a reasonable delay. This is part of our mission. So, therefore, our conclusion is that an important number of civil parties wish that the trial continue, but among these civil parties, an equal number of civil parties consider that non-judiciary measures could address their needs for justice and for support. Regardless of the Chamber's decision, it will be up to us afterwards to explain this decision to the civil parties and to develop measures that will make it possible to address their expectations beyond the trial. I hope that I was clear, and of course I can answer the Chamber's questions if my explanations were not sufficiently exhaustive. And now I will give the floor to Ang Pik, whom I believe has additional information to provide.
Yes, Councillor Pik Ong, you have the floor, says the President. Pik Ong. Good morning, Your Honours, and good morning, parties and the general public, as well as the civil parties who are present here today, and who are following the proceedings remotely. My partner, Marie Giraud, has informed the Chamber on the many points that we have already. And I only would like to make supplementary remarks as follows. The civil parties that we had conversation and consulted with would like to have the remaining charges be heard by the Chamber, and that was by the majority of the civil parties, and only a small number of civil parties do not wish to hear the remaining charges be heard, since they believe that the suffering that they had endured during the period of 75 to 79 is sufficient, and they do not want to see the remaining of these suffering return, and that they wish not to bear the suffering again. And that is the main concern, that they do not want to recall the suffering that they endured and not want to hear the remaining charges be heard. And among all the civil parties, as Marie Giraud informs the Chamber, there are elderly civil parties, and there are those civil parties who are sick, and there are also civil parties who passed away. And their wish as a civil party is to have the strongest support, that is the support for them health-wise, physically and emotionally, before they die. So for the trial chamber, as well as for the relevant parties who may lend support to the civil parties, please pay attention to their need in their capacity as the surviving civil parties and the victims. And I request that the support for the civil parties should be as much as possible, or other measures should be taken to lend support to them. And that is all I want to raise, Mr. President. And allow me to sum up that generally the civil parties would like to have the remaining charges be heard. However, their main priority and need is the support for their health. Thank you.
Just one comment to avoid confusion for the public. Non-judicial measures are called non-judicial measures because the court is not involved in them. So the trial chamber cannot, under the rules, order non-judicial measures.
Madam Judge. Yes, we clearly understand about the differentiation. However, I would like to have the voice of the civil parties heard in this courtroom. Thank you. President, thank you. The floor is now given to the co-prosecutors to make their oral submission on this matter.
Thank you, Mr. President. Good morning, Your Honors, Counsel. Your Honors, the position of Chea Liang and myself remains the same as we submitted in writing in document E49/3. But also this has been our position since before the start of Case 2-2. At that time, many people doubted there would even be a Case 2-2. We did have an order from the Supreme Court about what the scope of that case would be. And what we have now accomplished, because we've basically completed, we're at the point of completion of that case, perhaps one more witness, is a larger case, a broader case than I believe anyone had imagined previously. It's much broader than the order of the Supreme Court on the severance of 2-1 as to what 2-2 should include. It's even broader than the prosecution's submission before the start of 2-2 about what the scope of the trial should be. It's important for everyone to understand that Case 2-2, the combination of cases 2-1 and 2-2, has now covered all of the legal charges in the case. Not every location will have been covered. Not every one of the security centers, for example, that were charged in the closing order are covered. But each of the charges of murder, extermination, genocide, forced marriage, rape, etc., all of these charges will have been covered. In my experience in war crimes cases in various countries, including here in Cambodia, is that victims have a great desire to see justice, and there's no question about that. And I understand the lead co-lawyers expressing that very strong desire of the victims to see what happened to them recognized formally in a court. However, in every place I've been, there also has been criticisms that why does the process take so long? Why does it cost so much money? When you're dealing with massive crimes, and there hasn't been a trial more massive, dealing with more massive crimes since World War II, than this trial, it's impossible to cover every crime against every victim. There are 3,860 civil parties participating in this trial, but the facts show that there were millions of victims of the crimes of the DK regime. Even in the closing order charges make certain charges. For example, it includes several additional security centers. But that itself, of course, was just a selection of the over 200 security centers where, in fact, Cambodian people were victimized during the DK regime. In order to do an efficient trial, there has to be, it's a just simple matter of practical common sense, a selection of crimes that will be proven at the trial that are representative of the policies and that encapsulate the criminal behavior that's involved in the case. That, I believe, has been very well covered between cases 0201 and 0202. As I said before, all legal charges are covered. And I believe all the victims of the regime, all of the civil parties, including the 60 mentioned by the lead co-lawyers, and the millions of others that are out there, can take a great deal of satisfaction in seeing that these crimes and these policies of the regime were covered in these two trials. I would remind everyone of the criteria, in fact, to participate as a civil party. I don't recall off the top of my head the document number, but I'm sure we all know that during the earlier proceedings, before the case got to the trial chamber, there was an appeal to the pretrial chamber by civil party applicants. And the pretrial chamber made clear that anyone who was a victim of the regime, who was a victim of the crimes in a broad sense charged, could participate as a civil party in case 2-2, even if the particular location where they were victimized was not in the closing order or a subject of the initial submissions, a subject of the investigation, because this was a case about national policies. So all of the victims of those national policies could participate as civil parties. We think it makes no sense to have a third trial in this case, given that all of the legal charges have been covered. The proceedings have been going on for many years. There still is the very strong possibility that there will be an appeal. We're still going to have some time for a judgment in case 2-2, and then an appeal in case 2-2. All of that will, of course, by necessity, delay the ultimate enforcement of the sentence that we now have from case 2-1, the actual transfer of the accused to a facility, Cambodian detention facility. And we think it simply does not make sense to continually try this case until everyone is deceased. We think the trial has been broad. It has covered all of the policies, criminal policies of the regime. The charges between the two trials are representative of those criminal policies. And I think all of the victims, both civil parties and those not participating, can feel a great sense of justice if the crimes against them are recognized, if the policies of the regime, the criminal policies of the regime, are recognized by the court. Thank you.
President, thank you. And the chamber now gives the floor to the defense team for Mr. Nguyen Chie. You may now have the floor.
Yes, Mr. President, thank you. We are in a bit peculiar position, I would say, to have to respond to the civil party application, although from a certain perspective understandable. we, of course, nevertheless fully agree with most of the submissions from the prosecution. We had a very extensive debate before the start of trial 002/02. All parties at the time were able to give their input as to how we should proceed in that second trial, which charges should be dealt with. We had our say at the time, and it is indeed true, as the prosecution remembered, that in 2013 actually nobody thought that there would even be a second trial. And it is indeed correct as well that the charges that Nguyen Chia has faced in 002/02 have been much broader than the minimum that was advised by the Supreme Court chamber. I think it would be very fair to say, although unspoken, that it is extremely unlikely that there will be a third trial. There is really no legal necessity whatsoever to have a third trial. In the highly unlikely scenario that there would be a third trial, I would just like to make two very brief points. First one would be that to remind the Chamber of the concern expressed by the Supreme Court Chamber in its decision of 8 February 2013, before the second trial would start, the concerns expressed about, as laid down in paragraph 51 of that decision, actual or appearance of bias of judges from the previous trial adjudicating the second trial. So the Supreme Court Chamber at the time had concerns about which judges should adjudicate a second trial. There were concerns that if these judges would be the same judges as in the first trial, this would raise concerns as to the bias of judges. It will come as no surprise, Mr. President, that we will be arguing in our closing brief and closing submissions that all judges of this chamber have shown extreme bias in adjudicating the second trial. So if there is to be a third trial, God forbid, there should be definitely other judges appointed, both national and international. But as I said, it's a very academic situation that we're dealing with. The second point that we would like to make is the following. I'm not quite sure if I understood the summing up of the lead co-lawyers correctly, but again, I didn't hear them talking about charges in relation to the security center at Krautsmar. The response to the submissions of the civil party lead co-lawyers was specifically about this very issue. I would like to remind the Chamber again of our filing on the 19th of September 2016, in which we argued that it seemed that the lead co-lawyers for the civil parties had deliberately excluded Krautsmar Security Center from their listing as to crime sites which should be tried in case 3. Krautsmar Security Center, for the benefit of the public, was a security center that was run in the East Zone, and crimes committed there would of course be crimes for which present highly ranking government officials would be responsible criminally, would be liable criminally. So if again, in the highly academic scenario that there would be a third trial, we would argue strongly that the Crouchmar Security Center and the crimes committed allegedly in 75 in the East Zone would be added to the list of potential crimes. I believe these are the two things, Mr. President, that I would like to say.
President, thank you. And now it is the last floor. The chamber hands the floor to the defense team for Kyo Somphone to make an observation on this matter. You may now proceed.
Merci, Monsieur le Président.
Thank you, Mr. President. Good morning. Good morning, everyone. We, the Kyo Somphone defense team, find that the situation is very clear. You have no choice but to put an end to the proceedings for the remaining charges. And since no one went into the details of the grounds on which you would make that decision, I would like to revisit that issue. The co-prosecutors, in their response to the civil party application, referred to Rule 89 quarter of the internal rules, which enables you, and I quote, to reduce the scope of the trial by including a number of facts mentioned in the closing order. End of quote. The Kyo Somphone defense team would like to underscore the fact that if you believe you should put an end to the remaining charges, it wouldn't be in application of this article, of this internal rule. So, from memory, I do recall that we had strenuously objected at the time of its presentation during the plenary session. And I would like to explain to the chamber, perhaps I shouldn't do that because they are aware of our submissions at the time, but let me explain to the public that this rule is unlawful since it violates the principle of legality in Cambodian law, and since in civil law it is the co-investigating judges who decide to seize the chamber, and you cannot violate that decision and the manner in which it was taken pursuant to Article 89 quarter. But we objected to that rule because in Rule 89 quarter, paragraph 3, it was envisaged, and I quote, evidence relating to the facts excluded may be relied upon to the extent it is relevant to the remaining facts. End of quote. And the reason why we objected to this rule was not because, as defense counsel, we would have a position that is contrary to the interests of the accused, which is to object to the abandonment of charges, but precisely because if they say that the charges are abandoned, it is obviously because the facts referred to in those charges cannot be invoked for any reason, and it is because Rule 89 quarter, as far as we are concerned, is such a great and egregious violation of the principle of a fair trial, and that is why we are requesting the chamber to abandon the remaining charges. There is another reason which is clearer, and it is a general principle in international customary law, which I would like to re-emphasize, and I would like to recall the chamber to the fact that this issue of remaining charges was already dealt with. And it is because the Supreme Court Chamber said in 2014 as regards this subject, and I refer the Chamber and the parties to the decision of the Supreme Court Chamber, E301/9/1/1/3, which was a decision to the appeal we lodged against your new severance decision. And what had the Supreme Court Chamber recalled in that decision? And this time it was paragraph 69, that's paragraph 69 I'm referring to. The Chamber had ruled as follows, and I quote, "The trial chamber took no decision in this respect," that is with regard to the remaining charges. The Supreme Court Chamber considers that reducing or withdrawing charges requires an explicit decision of the trial chamber. This requirement being dictated by concerns of legal certainty as to the scope of the charges referred to in case 002. And on this point, the Chamber reached the following finding in paragraph 89. It had decided to stay the proceedings because it couldn't remain the charges that it hadn't ruled upon left hanging. And in July 2014, in paragraph 90, it stated the following: "This stay is provisional, but although it clarifies the formal status of the remaining charges, it does not alleviate concerns about the right to be tried within a reasonable time." To this end, the Supreme Court Chamber urges the trial chamber to fulfill its duty to bring closure to the entirety of the cases before it. End of quote. In July 2014, therefore, the Supreme Court Chamber requested that the Supreme Court Chamber issue a decision and it urged the Chamber to explain the way forward regarding remaining charges. In the paragraphs I've just quoted, we have two important elements: legal certainty and reasonable time. We have a situation where in 2014 it was considered that there was an interest in legal certainty, and it was also considered that the situation was urgent, such that the principle that the accused be tried in reasonable time should not be violated. And we have a situation in which the issues raised at the time about legal certainty and timeliness, we find that today those issues are even more important for Mr. Keo Sampang than ever. And that is why in 2017, close to 7 years after the issuance of the closing order, close to 6 years, in 2011, that was when you took your first severance decision. Close to 6 years after that initial severance decision, we have this situation of legal uncertainty as regarding the remaining charges. So today you are obliged to find that it is impossible to ensure a trial in reasonable time and with certainty regarding the remaining charges, because it is impossible for us to guarantee those principles. So we must put an end to those charges. A while ago, I referred to a principle in international customary law, and I referred the Chamber as regards to jurisprudence to the Lubanga appeal judgment. I refer you also to our submissions requesting a stay of proceedings in August 2013, document 75/2/1/1, particularly in paragraphs 3 and 7. And we request you quite simply to find that it is impossible to conduct a fair trial in a reasonable timeline. And for that reason, you should find that you don't have any other choice but to put an end to the remainder of the trials in case 002/02, which was the subject of this trial. And I would like to add that the reason why it is all the more impossible to envisage a trial in a reasonable time as regards the remaining charges, and in the same decision of the Supreme Court chamber that I quoted a while ago, document E301/9/1/1/3 in paragraph 76, we see the effects of your severance decision mentioned, and this is what was stated therein, paragraph 76. Now, if the new severance of charges in case 002 is confirmed, the trial chamber's decision to sever the trial prior to the evidence in case 002/02 will cause a severance in case 002 and any other cases on the remaining charges referred to in the closing order. If the evidence produced in the various trials would arise from the same common basis. End of quote. That is what the Supreme Court chamber stated in July 2014. So not only do we have a problem of lack of reasonable time, since the closing order, let me remind you, dates back to 2010, but we have another problem, which is that as regards any subsequent trials that could occur following the severance decision you took in case 202, so we don't have a common basis, which means that you have to start from scratch. That is what the Supreme Court chamber ruled. Under such circumstances, the principle of being tried in a timely manner is not possible, and that is why you have to abandon those charges. And I refer you again to the closing order, which we refer to in our submissions, 2013, for purposes of completion. And this ties in with the second element. We've talked about applicable law today. We've talked about principles, but I believe that bearing in mind the elements that we're focused on and which underscore the positions of the various parties, we find that we are all conscious of the fact that the issue of the merits arises. The issue of the merits of a subsequent case arises. We shouldn't be naive. We see that that issue of merits is fundamental, even though it shouldn't be the basis of discussions as part of a trial. Since we're talking of justice, I wanted to make these remarks. In any case, we find the conclusion of the Kyo Sampan defense team is that you don't have any other choice but to put an end to the proceedings.
President, the Chamber is grateful to all parties for making submissions on this matter. The Chamber will take all the comments and observations into consideration and issue a decision in due course. There's another matter that the Chamber would like to address. Now is appropriate times for rest. The Chamber will resume at 10:20.